Okay, good day everyone. Welcome to our course Obligations and Contracts. This is for CITU ETEEAP Remediation class. I am your presenter. My name is Lyndon A. Maceren. I have a jurisprudence, Doctor of Jurisprudence, Masters in Bachelor Business Administration. I'm a certified public accountant and also a licensed real estate broker. Still working on my doctorate Business Administration. I only lack dissertation to complete it. And I'm a lawyer. Okay, then we will start our lesson with expect from this course. So, of course, you'll be introduced to law, business law, and the obligations, its definition, sources, the requisites of obligation, nature and effect, and the modes of extinguishing obligations. Then on part 3, we will discuss contracts, definition up to defective kinds of defective contracts. Okay, we begin with the definition of law. What is law? Law is a rule of conduct, just and obligatory, promulgated by a legitimate authority for common observance and benefit. Now, here are the characteristics of law. Firstly, as a rule of conduct. So in any things or any actions that we do, that it is promulgated or regulated. No? Like, like for instance, if you drive a vehicle, you cannot drive a vehicle if you have no license. Because this, why do you follow this? Because it is a rule of conduct. Though driving is a legal act, but it is still regulated by the state. Okay, so once getting the license, you're obligated or mandated to follow the rules, the traffic rules, as well as the, uh, the new laws that are set up by the state, like the Anti-Destructive Driving Act. So the law should be promulgated by a legitimate authority. So in our state, the Philippines, it is the legislative branch that promulgates laws. We have three branches, namely legislative, executive, and judiciary. But the laws are promulgated by the legislative branch. Laws should be just and obligatory. So meaning a law should be fair or just. If it is unjust, it would be uh, ruled out by the Supreme Court as void. No? Obligatory, meaning everybody is mandated to follow. No one is above the law, regardless of his sex, creed, age, or status in life, position in the government, or being an officer or not. So it should be equal. Obligatory means any duty which is binding parties to perform their agreement. And common observance of the law will benefit everyone. So application of law should be titled or favoring an individual but by the observance of all, and which would benefit everyone. So there are different sources of law, namely constitution, legislations, administrative acts, jurisprudence, and customs. Constitution, we have the 1987 Constitution, which was enacted or ratified by the people in 1987. So it is the most fundamental law or the basic law of our land. So all laws must conform with the Constitution. So legislations, these are the laws enacted by the legislative branch. Legislative branch, which is Congress, divided into two houses, namely the Senate and the House of Representatives. Administrative acts, these are the implementing rules and guidelines or implementing the rules and regulations which are made by the different agencies of the executive department. Now, the executive department is the one who executes the laws which are enacted by the legislative branch. and some of the laws passed by the legislative branch lacks details on how to implement it. That's why the executive branch would promulgate or make their own rules and regulations in implementing the act. No? As an example, labor law or labor code was enacted by the late President Marcos, Presidential Decree 442. But then there are rules and regulations in implementing it, which was promulgated or uh, drafted by the executive branch under the Department of Labor. No? So the Department of Labor is the one making or promulgating the implementing rules and guidelines. Okay. So the fourth source of law are jurisprudence. What are jurisprudence? These are Supreme Court decisions and rulings. And according to the Constitution, Supreme Court rulings form part of the laws of our lands. So jurisprudence is one source. Another is customs. We have old and bad uh, customs, but this one only old and good traditions. These are practices which have been known by our elders since time immemorial. So now they are part of laws. No? Okay. So there are different branches of our laws, namely political, criminal, civil, and procedural or adjective or remedial. Political laws, this covers election, territorial, political, international laws of our states, like the laws of the sea, which is the one which is governing the disputes in the South China Sea. The second branch of our laws are criminal laws. There are two kinds of criminal laws under the RPC or Revised Penal Code and special criminal laws. The These laws defines the different crimes, its elements, and provide for their corresponding penalties. Then the third branch of our laws is civil law. These are a body of laws that govern the different relations of individuals and their property, defines rights and obligations, and remedies in case of disputes. Okay. Now, fourth one is adjective or remedial law. Laws which provide the procedures in enforcing or maintaining rights or obtaining redress for any violation or invasion. Now, obligation and contracts, this course is under which branch? Number three, civil law. No? So we will obligation contracts under civil law. Now in civil law, on the other hand, there are 6 books. And civil law contains approximately 2,200 articles. Was promulgated in June 1949 and took effect the following year, 1950. And this is known as Republic Act 386, the Civil Code of the Philippines. There are 6 books which are as follows: Human Relations, which is now the New Family Code of 1988. This governs the relationship of different family members, the society as well. Well, if you want to uh, make a research on how uh, annulment or declaration of nullity of marriage is the law that governs the nullity of marriage is here in the family code. Marriage, adoption, that's right. I don't know. Marriage, what else? The relationship of every family member, parents to children, and children vice versa. Okay, second book is succession. This is the law which governs the rights and obligations of the heirs or the successors. when a person dies, no? And this person who died left several properties. And the division of properties is governed under Book 2, Succession. The third book of civil law is property. Property are according to who finds the property, who owns the property if a property is found, or who owns the property if the property is a product of recession, or like when it just grows there. Uh, there's a river and the river transferred to another location. Now, who owns the portion of land which is left by the water? You know, there are cases like that. So this is covered under Book 3, which is property. So Book 4, which is obligations and contracts, is from Article 1156 to Article 1430. So we'll discuss that later. Book 5 is trust, and 6 is about sales. So obligations and contracts. We'll discuss with defining obligation. So under Article 1156 of the Civil Code, obligation is defined as the juridical necessity to give, to do, or not to do. Juridical means means the relating to law. So a necessity which is a product of law, giving, doing, and not doing. So the kinds of obligations in the definition, there are three. To give, which is a real obligation; to do, which is a personal obligation; and not to do, which is a negative personal obligation. So as an example, the first one, to give, Eve promised Mario that she will repay her loan of 10,000 pesos tomorrow. So it involves here in this obligation, it's covered by a contract of loan, and the obligation is giving of 10,000 pesos. So this one falls under real obligation. And the second one, to do, it's a personal obligation. An example here, Sarah agreed to sing 3 songs on Mimi's wedding party. So Sarah has obliged herself to sing 3 songs, probably Sarah Geronimo, on Mimi's wedding party. So this kind of obligation is non-transferable because it is personal to the obligor. The third kind of obligation is the negative personal obligation, which is not to do. Example here, Eve obliged herself not to fence her backyard so her neighbors can have access to the main road. So the location of Eve's house is near the main road, and if she would fence her backyard, the neighbors, the back of her house, can no longer access the main road. So she obliged herself, so made a promise to the neighbors in the back of her house that she will not fence her backyard. So this is an example of negative personal obligation. So there are elements of or requisites of an obligation. So meaning if one is absent, then there is no obligation. And in the case of obligation, there are 4 requisites: passive subject, active subject, object or prestation, and lastly the legal or juridical tie. The passive subject is known as the obligor or debtor, and it's defined as the one who has the obligation to give or to do or not to do. So this is the person who is required to deliver, required to perform, and required not to perform, or required not to perform. On the other hand, the second requirement or element is the active subject. This one is the subject of the contract, who has the right to demand. You know? So she or he is the obligee or the creditor. and the creditor. Okay. Now in an example, go to our example here. Eve promised Mario that she will repay her loan of 10,000 pesos. So the passive subject in this example, or the obligor or debtor, is Eve, no? Because Eve is the one obliged to perform, which is to deliver the money tomorrow. Now the active subject, who's the creditor or obligee, in this example is Mario. So Mario is the one who has the right to demand performance, or the right to demand the subject matter. Okay, so he is the creditor. Let's go to the third requisite or element of an obligation, which is the object or prestation. Now in this example, the object or prestation is the 10,000 pesos. So this is the subject matter, object, or prestation. So these are all synonymous. The fourth requisite or element is the legal or juridical tie. This is the efficient cause, and this is the legal tie between the parties. And it is the main criteria uh, to determine if it exists. So to determine if it exists, so the injured person can file a case before a court of law. Because if there is no juridical or legal tie, then the person, the creditor, cannot file a cause or cannot file a case in court. So here, the legal or juridical tie in an example is the contract of loan. Loan is a contract, and the parties in the contract are mandated to follow the provisions or stipulations of the contract. So if ever Mario will not receive Eve's payment of 10,000 pesos tomorrow after he makes his demand, then can he file a case? The answer is yes, because there is a legal or juridical tie, which is the contract of loan. Now there are obligations which do not have a legal or juridical tie, like a moral obligation of going to church every Sunday. Now, if a person or a devotee cannot go to church, question is, can the church file a case against this person for not complying her moral obligation of going to church? The answer is no, because there is no legal or juridical tie in a moral obligation. Okay. Another example: when a parent uh, uh, when a parent to a child, a parent would shoulder all expenses from the time the child was still baby up to the time she finishes her college or university education. And the parent has spent more than million pesos, you know, in in uh, in defraying for the cost, the food, the shelter, clothing of the child. So because it is the moral obligation of the parent to support the child. The question is, the child obligated to repay all her debts to the parent? Can the parent demand that the child pay? The answer is no. Why? Because there's no legal or juridical tie. Okay? Because what the parent was doing was performing her moral obligation. Okay? And this time also demanding moral obligation from the child. So in the object or prestation of obligation also has requisites. No? So in our example here, the object is 10,000 pesos. So the requisite should be that the 10,000 pesos must be licit or legal or lawful. No? If it is unlawful, it is void. So void, what is void? void has no legal effect. So, example, Amy promised to build Matt a house on Matt's birthday. Is this a valid prestation or object? Object here is to build a house. So a house is valid because it is not illegal. No? A void example is when Amy promised to give Matt 1 kilo of shabu. So this one is obviously a void example of an obligation, being shabu being an illegal or illicit object. Now number two, it must be possible, either physically, no, not either, physically and juridically. So example, Amy obliged to give Matt a baseball bat for 500 pesos. So this is a valid example because it is physically possible and juridically possible for Amy to hand or give the baseball bat of worth 500 pesos to Matt. A void example is when Amy promised to build Matt a house in the middle of the Pacific Ocean. This kind of obligation is physically and juridically impossible. So this is an example of a void or no legal effect obligation. The third requisite that the object must be observed that it must be determinate or determinable. Otherwise, it is void. Now, determinate and not a generic or indeterminate object. So, determinate object is one that can be identified by its individuality, meaning you can specifically determine that this is the object being referred to. No? Example of determinate: a car with plate number uh, A, A, ASD 123. So it's got a plate number. But if you say a car, and that's it, it's generic. It cannot be determined uh, with with certainty. No, it cannot be certain. And if you say, I promise to give you a Toyota car, is that already determinate? The answer is no, because there are several Toyota cars in this country. It could be Toyota Innova or Toyota Fortuner, or it could be a Toyota high-ace van. So when you say Toyota car, that is still generic. So how do you make car determinate? By including its plate number. Or if it's object, by including its serial number. Okay, fourth, object requisite of an object in an obligation that it must have a pecuniary value, also known as juridical tie, which binds the parties, or the cause why the obligation exists. So obligation has its sources. The first one is law. If an obligation, if a law is a source of obligation, the law must be expressly or impliedly set forth and not presumed. Like for example, the train law, or prior the NIRC law. The train law is the tax train law. Forgot. Train law. No. So the train law is an example of a law. So it requires there that the payment of taxes should be made on or before April 15. So it is expressly stated. So there is no condition. It states that it should be paid on or before April 13. No demand is necessary. So if you fail to pay on this date, then you will be liable for delay, which would be in a form of interest uh, or compromise or another charges. No? So another kind of source is our contracts. So if you execute a contract with another person, then there are several obligations there. Like for example, a contract of loan. So once you get the money, it is stated in the contract that you will pay the obligation, either installment or one-time payment. No? So contracts must be observed with good faith. So no deception, no fraud, no bad intentions. The provisions or stipulations of the contract, so is the law between the parties. And we have also another source, which is quasi-contract. Quasi-contracts, there are two kinds, namely negotiorum hestio and solutio indebeti. So we'll discuss first negotiorum hestio. This is the unauthorized management. This happens when a person voluntarily manages an abandoned property or business which belongs to another person and without his consent. An example, Elliot's neighbor was in Baguio having a summer vacation. During that time, the neighbor's garage caught fire. Sunog. And then Elliot was there. He was able to put out the fire in a timely manner and save the house from burning. So in this case, the one who has the obligation is the owner of the house. And what is that obligation? Obligation to repay or pay for Elliot's effort in saving the house in a timely manner. No? So in this case, there is no consent from the owner of the business. Okay, because it was an emergency. So if ever Elliot was injured during his saving of the house, then the owner of the house will compensate Elliot for whatever medicines or hospital bills that Elliot will incur. So that is the obligation of the owner of the house. The second quasi-contract is solutio indebeti. This happens when a person unduly delivers a thing through mistake to another person. And this person, who is the recipient of the thing, has no right to demand the thing. So there is mistake. In our example here, Chip, person, went abroad to work. So he is an OFW. Upon saving enough money, he deposited 100,000 pesos to his parents' bank account here in Cebu. Then he called up his father and informed him of the news. So his father went to the bank and inquired on the balance of his bank account. But to his surprise, there was a deposit made for 1 million pesos. So the bank committed an error by wrongfully entering 1 million instead of 100,000 pesos. Now there is, but instead of correcting the error, the father of Chip withdrew all the money and spent it. So this is an actual case. This actually took place. No, the Supreme Court ruled when in this case what happened here, the parents of the OFW went on a tour around the world because they received dollar. No? It was dollar figure, I think, 6 figures in dollars. So they wasted the money. Then, upon returning here in the Philippines, they were arrested for deceiving or committing estafa, fraud, no, against the bank. And because instead of correcting the error, the parent of the OFW withdrew all the cash. And there was an error on the part of the bank. So the obligation here lies on the person who received the money or received the thing by mistake. So Chip's dad the is the one obligated to return the money to the bank. Okay. Now the fourth source of obligation are delicts. What are delicts? These are maleficio or delecto, coming from ex delecto. These are Latin terms, which means crimes. No, crimes. So the crimes are governed under the revised penal code, and in Article 100 in the revised penal code states that a person who commits a crime is for a felony is also civilly liable, which means that he does not only go to prison, but he is also liable to pay for civil damages. Now we have example here. X raped and murdered G. G was a manager and only 33 years of age. So according to the civil liability of the civil code, the first liability is restitution or restoration. So in this case, since G was already dead, X cannot anymore restore or restitute the life of G. So he must pay. No? Then, secondly, X must pay for the damage caused. So whatever damage caused, this includes funeral, burial expenses, and other sorts of costs, uh, damages. Thirdly, the murderer, the rapist, will be liable to indemnify for consequential damages. Consequential damages are the salary of G. So X will be liable to pay for salary of G. Let's say the salary of G is being manager is 35,000 a month. So 35,000, and she's still 33 years old. The productive year of a Filipino is ruled to be 6 until 60 years old. So 60 minus 33, so X will be paying the family of G 35,000 a month for 27 years. No? Okay, so that is indemnity for consequential damages. Then the last source of obligations are quasi-delects or torts. So torts mainly is an act or omission arising from fault or negligence, and which caused damage to another. So there is no pre-existing or contractual relations between the parties. So then we define negligence. What is negligence? This is the one's failure to observe diligence or that degree of care, precaution, and vigilance which the circumstance justly demand. So there are different kinds of diligence. Firstly, extraordinary. These are required of public transportation like a taxi cab or a bus or jeepney, airplanes, and others. Then we have ordinary. This degree is same or similar to that as a good father of a family, because a good father of family always protect his family. Now, diligence agreed by the parties is the third kind of diligence. So there are different kinds of quasi-dialects. First is culpa aquiliana, then culpa contractual, and culpa criminal. Example of culpa aquiliana is Randy broke the windshield of Ed's car after carelessly throwing a baseball. So there is negligence on the part of Randy, carelessly throwing a baseball to the windshield of Ed's car, causing damage. So there is no contract between the two of them. So this one falls under culpa aquiliana, no existing contract. On the other hand, culpa contractual, here there is existing contract between the parties. So example says sustained injuries when the taxi cab she was riding turned turtle. Okay? Himong bao. Dili day. Natuwad, no? It flipped. So turn turtle means the car flipped or turned upside down. So in here there is a contract. What kind of contract? It is a contract of carriage. No? So when you take a public utility, it holds under contract of carriage, and this is a common carrier for public utility. So the diligence that the taxi cab owner and the driver must follow is the extraordinary diligence. So if there is injury on the part of the passenger, they are presumed to be negligent, so liable to take care of the cost to heal. No? The third kind of quasi-delict is culpa criminal. Culpa criminal, there is a crime. No? Culpa, by the way, is uh, negligence, no? Or tort. Culpa criminal, example, there were 18 pupils who died after eating cassava cake, which were bought from the cafeteria of the school. So in this example, this is also an actual case in Bohol, but it was not a cafeteria, it was a vendor selling cassava cake. So it was an ambulant vendor. So here, the pupils died. So there is no intention for the uh, seller to kill these pupils. It was accidental, but there was negligence on this part. So on the part of the seller, so she must pay, or otherwise she will go to prison. No? So she must pay for the burial, the whatever costs in restoring or restitution. So the same as that of a person who commits a crime. So we discussed the different duties of a debtor who promises to give a determinate thing. So again, determinate thing is one which is identified by its individuality, meaning it is unique. So in this example, a sports car, Toyota 86 with plate number ASA 222. This car is unique. It has its plate number, so it is a determinate object. So the person who obliged herself was Eve. Eve obliged herself to give Sue on her birthday a sports car with plate number ASA 222. So her duties while making that after making that promise, let's say for example Sue's birthday is yet 2 months after, no? So from the time Eve made that promise until the time of delivering the object, she is obliged to preserve the thing and in the diligence of a good father of the family, and there she has to deliver its fruits. If the thing uh, the thing bears fruits. There are different kinds of fruits: natural, industrial, and civil. Natural fruits, these are uh, grown naturally. No? There is no human intervention. For example, a papaya tree just grew on its own, and then it has fruits. So the fruits of the papaya tree is natural, falls under natural. But industrial, here there is human intervention, meaning there's human cultivating the farmland, planting the seeds, uh, then irrigating the soil and fertilizing and so on and so forth. So the crops that that farmer will harvest are fruits of called industrial fruits. On the other hand, civil fruits, these are fruits which is a product of capital. You know? If you have money, you buy an apartment and have it rented or leased out. So the earning or the rent that you will be receiving from a lessee is called civil fruit. So in this case, a car can be rented out. If Eve rented out the car, Toyota, let's say on a wedding, so it was rented for 3,000 pesos, then the 3,000 pesos should be given to Sue because that is already a civil fruit owing to the creditor. No, even though she has not delivered the thing yet, but since the day she made that promise, the fruit of the car shall go to the creditor. In this case, Sue. Okay, number three, duty of an debtor is to deliver its accessions and accessories of the thing. So what are accessions? These are additions or improvements upon a thing. So in a car, it is air conditioner. You know? So accessories, on the other hand, these are things joined to or included with the principal for better use or embellishment. So example are a key of the car or the mag wheels or alloy wheels. No? So Eve cannot say, I will replace these wheels of the car with ordinary, no? And I will sell the mag wheels. No, it's part of the duty of the obligor when she made that promise. And then fourth duty is to deliver the thing itself and to pay for damages in case of breach, negligence, fraud, delay or contravention of the tenor of the obligation. Now this breach and contravention of the tenor of the obligation are synonymous. They are the same. No? Breach and contravention of the tenor of the obligation. So we have discussed already negligence and slightly on fraud. Fraud is estafa, deception, or any kind of panikas, tikas fraud. Now we will discuss delay. Oh, no. So what if a person promised to deliver an indeterminate or generic thing? Let's say I promise to give you 1,000 sacks of rice. So that is a generic, no? That kind of promise is generic. So what are these obligations? Here, May promised to give Angie a high-end smartphone on her birthday. So the subject here is smartphone. The phone here is generic because it is not specifically identified. So what makes a thing or a smartphone determinate is that it is unique, identified by its individuality, such as, in this case, a serial number. But since May did not give the serial number of the smartphone, so what she promised to give falls under indeterminate or generic object. So these are the obligations to deliver the thing, which is neither superior nor inferior quality. So it must be moderate, or in other words, a regular kind of generic, no? Not superior quality or of inferior quality. So regular lang, normal quality. Number two, to pay for damages in case of delay, fraud, negligence, or breach. So these four here, delay, fraud, negligence, or breach, are the sources of damages. So first source is delay. Now delay happens when a person fails to deliver the thing due or fails to perform the services within the period promised. And if it is committed by the debtor, it is called mora solvendi. Okay, delay in Latin is called mora. Okay. So, an example: Bo promised to G an expensive watch on New Year's Day. So on January 2, G demanded from Bo the delivery of the watch, but Bo never showed up. So this is after 1 day from New Year's Day, G demanded from Bo. So here Bo is guilty already of delay. While under the general rule of delay, delay only happens from the time or the moment that the creditor makes a judicial or extrajudicial demand. So here in our example, Mr. G, the creditor, already demanded from Bo the delivery of the watch. This demand is under extrajudicial. Extrajudicial meaning outside of court. No? So G demanded already from Bo. So there was demand, so there was also a delay. Because if there is no demand, there is no delay. Judicial, on the other hand, is before a court. No? So this includes the filing of the case already. So there's a demand to pay, and it is filed before a court of law. So there are exceptions where demand is not necessary. Like I said, the law. No? When the law or obligation expressly so declare, it is stated in the law that payment of taxes must be made on or before April 15. So there is no demand necessary, that because the law specifies that it should be made on or before April 15, or when the obligation expressly so declare, it is agreed by the parties, no, that I need not, or the creditor need not make a demand, and delay will happen automatically. Number two, when the nature and circumstances of the obligation, this pertains to uh, the nature. Like for example, you are in catering business, and you enter into a contract, and that you will cater the wedding celebration or reception of Mr. Juan de la Cruz, no? Which will take place tomorrow at lunchtime. So we all know that lunchtime happens between the hours 11 o'clock in the morning up to 2 o'clock in the afternoon. No, so in this case, if the catering services will not show up between these hours 11 in the morning up to 2 in the afternoon, will only show up in the reception at 4 o'clock in the afternoon. So he is already guilty of delay. No? The catering is already guilty of delay. There is no demand necessary. And the third one is when demand would be useless. This happens when the thing to be delivered is already lost. Let's say, for example, Mr. Bo here promised to G that she will this one expensive watch, no, on her. This one's not generic, so let's take another example. If Bo promised to deliver G his dog, and the name of his dog is Chiquita, but before delivery on New Year's Day, Chiquita was unfortunately run over by a truck. So Chiquita died in that very moment. Patay na, ngiro. In this case, no demand is necessary because demand would be useless. No? Automatic. Then the debtor is guilty of mora solvendi. Question: what if the debtor fails to deliver or perform the obligation because of events or circumstances beyond his control? Is the debtor still liable? So firstly, we will discuss what are these events or circumstances which are beyond the control of a person. These are called the fortuitous events. There are tsunami, flood, typhoon, lightning, earthquake, war, riot, coup d'etat, robbery. So these are the first group is under the acts of God or force majeure, and the second group falls under acts of men. No? Can you control war? The answer is no. Can you control flooding? The answer is no. So if a person or the debtor fails to deliver because of one of these causes, like earthquake, is he still liable to perform? The answer is no, because it says here that no person is liable for fortuitous events. But there are exceptions to the general rule. No? So when it is expressly declared by law, when there is a law stating that you are still liable for a fortuitous event, then still you are. And number two, when it is expressly stipulated in the contract. When the contract states that you are still liable in case of fortuitous event, then you will be liable. And then number three, when the nature of obligation requires assumption of risk. Who are these persons who assume risk? These are the insurers, no? The insurance companies. So when something happens to the insured, say for example, the insured was hit by a lightning, they cannot say, hey, that lightning was an act of God, so we will not pay. No, sir. Insurance companies are liable for assuming risk. Number four, when the obligor has promised to deliver the same thing to two or more persons who do not have the same interest. So this should be persons. So this is a kind of fraud because obligor promised to deliver same thing, the same object to two persons. So one person came up, you want to buy this one? Okay, for 500 pesos, I deliver this to you. Okay, I deliver this tomorrow. Another one, he claimed already another 1,000 pesos. So he collected the money, but uh, promised to deliver the thing tomorrow. So this kind of transactions are fraudulent. No? So even though the thing was lost due to fortuitous event, like it was hit by a bullet during robbery, then the debtor cannot escape liability because he made a fraudulent transaction or is guilty of fraud. Number five, when the obligor is guilty of delay, fraud, negligence, or breach of the terms of agreement. So these four here are causes for payment of damages. So he has already incurred delay, then regardless if fortuitous event will take place after committing delay or fraud or negligence, then he is guilty of uh, he will still be guilty of delay. Okay. Also, when a person promised to deliver a generic object, like say I already made an example, a car. If I say I'll give you a car tomorrow, so that kind of promise or the thing promised is generic, no? And then my car was lost brake when somebody was driving, then it lost uh, its brake system, and it fell, no, from a cliff, and killing the driver also, and the car was total wreck. So there's nothing you can do. So you say, hey, I cannot give you the car anymore because the car is lost. But what you promised is a generic object. So under the principle here, the generic object never perishes. It's under the principle of genus non quam peruet. So regardless of what happened to the generic car, whether it's your fault or not, the debtor is still liable to deliver a car, no? because you cannot say, hey, the car was already lost and it's not my fault because somebody was driving it, the brake system failed, now it fell on the cliff, from the cliff. You cannot say that because generic object never perishes. Okay, when an obligation consists of payment of interest or payment by installment, the law requires that the creditor, the law requires that the creditor, in issuing the receipt, must make reservations, no? Because if you issue a receipt on a later date, it gives the presumption that the interest has been paid. Or if it's a payment by installment and you issue a later date, it gives the presumption that the prior installment or installments have been paid likewise. So example, for the first paragraph here, let's say D is indebted to C 10,000 pesos and an interest is involved of 1,000 pesos. So upon paying 10,000 pesos without the interest, the creditor C issued a receipt stating full payment of the loan. So question, can C still collect the 1,000 pesos from D? The answer is no, no more. Why? Because the receipt here clearly states that it is already full payment of the loan. So once a principal obligation has been extinguished, it carries with it the accessory contract. The accessory contract here is the interest, no? So there is no reservation made on the receipt. So the receipt should state here that payment of the principal loan only. Interest is still pending. So not yet collected. Okay. Now another example in the second paragraph where the debt payment is by installment. So example, if D buys a motorcycle from C and payable in installment at 3,000 pesos per month, then D failed to pay for the month of January, but at the end of February, D paid C, meaning February 28th, D paid C, and then C issued a receipt stating that the payment was for the month of February. Now, what is this receipt states that after because the law presumes that Mr. D here has already paid also for the month of January, because February is a month after January. If the buyer can prove that he has already paid for the month of February, it gives us the presumption that the prior months or the prior installments have likewise been paid. You know? So that is Article 1176.